Good afternoon, everyone. Nice to see you all here. For those of you whom I have not met yet, my name is Art Byrne. I'm a professor of Business Information Systems and Business Administration. And on behalf of the Business Administration Department, Dr. Sitters, who is here, Don Pekoff, Dr. Pekoff, who is on hiatus at this point, could not join us, and myself, Art Byrne. We're very proud to present to you a gentleman who is an expert in intellectual property. His credentials certainly speak for themselves. One thing that was added, along with all the other credentials he also has a master's in information science, computer science. So he can cover the gamut between law, patents, electrical engineering. He's well-versed in all of them. And I just want to say we're very fortunate to have this level of individual take the advantage. He will be taking questions. I'll be walking around with a wireless mic. This is a time to really learn. He's not going to present this as a normal classroom situation. So if you have a question you want to ask about anything, ask it, and I'll certainly will take the time to respond to it appropriately. As I said, we're very fortunate to have him here, and one other reason, other than all his credentials, he's a tremendous UConn fan, and we're very fortunate that UConn is playing tomorrow for Colorado. Otherwise, we probably would have to reschedule this. So, I don't want to use up any more time. Alfred Fressola.
I'm going to talk about intellectual property. How many of you folks have some idea what intellectual property is? Okay, pretty good show of hands. Intellectual property is, just to backtrack a tad, is a form of property. And basically, before we go into any of this, there's really two major types of property. Personal property, you know, this cup, it's personal. I own it, I have it, that's mine. Anything that is physically transferable, like a car, your backpack, your shoes, whatever, that's personal property. And all kinds of property, and that's one major category. The other major category is real property. Real property is land, things that don't move, your house on the land, stuff like that. So what is intellectual property? Well, intellectual property is like a subset of personal property. It is considered personal property under the law. And what does that mean? Well, it basically means if you created it, it's your property. You own it, you control it, you can license it, you can dispose of it, you can do whatever you wish regarding it. So what we're going to be talking about is this intellectual property, which is and sometimes referred to as intangible personal property. Why is it intangible? Because it doesn't have any physical existence like this. It has only existence in that it was some creation of yours. Whether it's a copyright, you wrote a book, whether it's a trade secret, you came up with some secret formula that nobody else knows about, it's a brand name for a product that you're selling, or it's an invention, regardless of what type of invention. Let's say it could be a new type of computer, it could be a new type of car, it could be anything. That's on the patent side. So there's really four major branches of intellectual property, which we'll get into in a second. So I will talk about all four on a survey basis, but because some parts may be of more interest, maybe the copyright side, maybe the patent side, maybe some of the material later on regarding some of the smartphone litigation, because I guarantee everybody here has a smartphone. We can talk about it. And what I don't want is people not to ask questions. Please, if you have something you want to ask, just either stand up, raise your hand. Dr. Byrne has a mic over there. He'll get it over to you, and we can go from there. So anyway, that's where we stand. So it's going to be an overview of intellectual property. A little piece at the end has to do with smartphone wars, and this is all the litigation that has been going on for the last really 7-8 years concerning smartphones. Smartphones are truly a quantum leap over the traditional cell phone. And because of that, there's been many, many patents that are directed to smartphone technology. My office was involved with quite a few of them with respect to one client, and we're involved in some of these smartphone wars. To a small extent, but nevertheless, we were involved in them. So we'll talk about that if we get to it and if you have an interest in hearing about it. So it's a little bit more like war stories. Okay, well, where does the two major branches of intellectual property, remember I said copyrights, patents, trade secrets, and trademarks. Well, the Constitution actually deals with two of them, and this was Thomas Jefferson who really came up with this. So it's Article 1, Section 8, Clause 8 of the Constitution. And it basically is, that Article 1 has to do with the powers of Congress to pass laws. So Congress has the power to do exactly what it says, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to the respective writings and discoveries. The interesting part is, if you look at it, it reads in parallel there. So it's to give rights to authors for their writings, and it's to give rights to inventors for their discoveries. And believe it or not, back then in the late 1700s, early 1800s, the primary thing with writings had to do with maps. Maps were considered very, very valuable. And the government wanted to make sure that maps that were created by cartographers were protected. So underlying it, that was it. On the inventor side, Thomas Jefferson was an inventor, as were a number of other of the founding fathers. So they understood that to promote what they saw as a differentiator of our country over, let's say, England at the time, was to promote the useful arts, promote new inventions, and that way they could differentiate themselves ultimately with respect to other countries that didn't have a similar patent system at that time. If you go way back in countries like England, France, and others, they did have the idea of patents, but patents were monopolies that the king gave to their best friends so that they would have the monopoly on importing tea or the monopoly on liquor and things of that nature. It was not for inventing things. Jefferson and some of the other founding fathers really saw the idea of patents was to promote the useful arts, and because that was the thing that they thought was going to help establish this very young country. And it actually did, no question about it. So what do we have? We have copyright covered by the Constitution, and notice it's exclusively federal. So that means if there's a dispute on anything to do with copyright law, you go to the federal court, not the state court. State court has no jurisdiction. Same thing to do with patents. They're both come out of that same clause of the Constitution. Again, it's exclusively federal. You have a dispute on a patent, you go to federal court. Trademarks is a little bit of a hybrid. Trademark comes out of the Commerce Clause of the Constitution, which is Clause 3, and we'll get into trademarks in a moment. But you can have a trademark both on the federal side, a federal registration, the R in the circle that you see on trademarks, or you can have them granted by your state. So the state of Connecticut, Secretary of State's office, you can get a state registration. These are typically for businesses that only operate in the state. So like a small restaurant might only register with the state with regard to their name. Trade secrets are governed virtually exclusively under state law. Trade secret is something that you keep as a secret that has some advantage to you. It might be the secret formula for Coca-Cola, that type of thing. It could be a customer list. It could be a lot of things that you have, nobody else has. As long as you maintain them in secret, it's considered as trade secret. If someone steals that, meaning they obtain that information through, let's say, breaking into your office, that's considered a theft. So we have it's more traditional state law that applies to trade secrets. The requirements of copyright are pretty simple. It has to be original, meaning you created it. It has to be fixed in some medium. So you wrote it on a piece of paper, you stored it on a server, whatever. You put it on a stone tablet, it makes no difference. As long as you fix it in a medium, whatever that medium is, and as long as you created it, it's your copyright. Okay. What is an original work of authorship? Independent creation. That's basically all it requires. You write a poem, that's independent creation. That's a work of authorship. It doesn't require ingenuity, it doesn't require novelty, it doesn't require aesthetic merit. In other words, no one's looking at your poem and saying, oh, that really wasn't very good. I'm not going to grant you a copyright. No, the Copyright Office simply says, as long as you created it, and as long as no one else has rights to it, you have the right to register that copyright. Simple as that. It's a registration process, not an examination process. And you'll see the difference in a moment when we get to patents. So these are examples of copyrightable subject matter. Literary works, musical works, dramatic works, pantomimes, basically anything that you think of in the arts and in things like computer programs. Those are all original works of authorship. They're therefore subject to copyright protection. So if you have a copyright, if you register your copyright, what are your rights? Well, you have the right to reproduce it. It's basically what the word says, a copyright. You have the right to copy it. No one else has the right to copy it without your protection, without your permission. You can prepare derivative works. You also have that right. Well, one of the main ones, of course, is a translation. I write a book in English. I have the right to have that book translated into any language I wish. I can revise it. I can abridge it. I can change it. I have the right to do it. Nobody else has the right to do it as long as I'm the author. So the rights under copyright are pretty extensive. And copyrights have an awful lot of interest, they are of major interest in things like the movie industry, television, the recording industry, because those are the things that fundamentally protect the works of authorship from being copied. Without copyright law, it would be basically it'd be like the Wild West. If you produced a new song, and you showed it, you did it at a performance, or you wrote the music, you wrote it out, somebody could copy it and use it without your permission, you basically have no rights to it. Copyright is the fundamental thing for protecting artistic expression. You can also perform copyright work, such as, if you wrote a play, you wrote a screenplay, you have the right to have that screenplay shown in a theater, for example. Who owns copyright? Well, the author owns it. So if I, as an author, write something, I own it. If two or three of you write something together, it could be a computer program, it could be a sound score, it could be a lyrics to some music that you wrote. If you jointly developed it, you jointly wrote it, you're all authors, you're all owners. Who else can be an author? Who else can own a copyright? A work made for hire. This is really the only exception to who owns the copyrighted work. And we'll get into a little bit more about transfer, but I'm talking about fundamentally who owns it when the work is created. Okay, what is a work made for hire? Well, the big one is number one. If you're, just remember this when you go out into the workforce. If you're working for someone and part of your job is to do something like, let's say, prepare computer programs or prepare an application program interface, anything like that. If that's part of your job responsibility, guess what? You don't own the work, your employer owns the work. And not only are they the owner, they're considered to be the author. So your name won't even appear on the copyright registration. That is the one, for people going out in the workforce, that's something to be aware of. You can also have one other situation for work made for hire, and that's when something is specially commissioned or ordered. I'm developing something, let's say I'm writing a collective work and I want you to contribute 2 or 3 chapters to that. I'm paying you for it. In that kind of a situation, as long as the agreement is written, then again, that would be considered a work made for hire. This gets a little bit regarding maybe the faculty. And the big thing is, what is this thing called fair use? You probably have heard about it. And fair use is the idea that even though something is protected by a copyright, therefore, if I'm not the author or not the owner of the copyright, I don't have the right to reproduce it. But there are some exceptions, primarily governed by the fair use section of the copyright law. So fair use is typically when you're allowed to make a single copy of a work, or sometimes multiple copies, but they have to be for a specific purpose. Fair use of a copyrighted work for purposes of criticism, comment, news reporting. So again, in a classroom environment, your professor may bring in an article that just appeared in the Wall Street Journal or the New York Times or the I don't know, what's the Willimantic paper? The Willimantic Gazette? Whatever, and you want to talk about it. Well, that is considered to be fair use. So the copying of an article that might appear in a newspaper that happened contemporaneously, you know, the day before, whatever, for purposes of classroom discussion, criticism, that would be considered fair use. What does that mean? That means the fact that the professor doesn't have to go knock on the New York Times, you know, their phone number and say, can I make 4 copies of this or 5 copies of this, or can I show it to my students? No, they don't, because it's considered a fair use. Factors for determining whether a fair use. These factors can get very involved. I will tell you right now, and when it comes to what can be used and what can't be used in a classroom, there's a circular, Copyright Office has a circular 21. I would strongly recommend any faculty to take a read of that, because it is fairly detailed, a lot more than what I think needs to be gone through here. But needless to say, there are various factors that are looked into regarding fair use. The purpose and character to use, whether it's to be used for commercial or nonprofit. Right off the bat, if you're using it for commercial purposes, it's not fair use. Forget about it. If it has to be nonprofit, like a school environment, a university environment. The nature of the copyright work, sometimes that is relevant. And the other question is, how much are you copying? You know, if it's a book and I'm copying 2 chapters, maybe that's not fair use. But if I'm copying 2 paragraphs out of 1 chapter, probably is fair use. Does it affect the market value of the copyrighted work? In other words, if I'm doing something that I claim is fair use, but I'm doing it in a way that actually affects the value of, let's say, the copyrighted book, because the author is not able to sell 50 copies of the book because I'm effectively copying it and giving it to my students, guess what? It's not fair use. Okay. Multiple copies are even more, you know, when you're making multiple copies for your classroom, the rules are even more stringent. It has to meet the test of brevity, spontaneity. Basically, again, a news story that just came out, something that just happened in the news, and you want to show it to your students, yes, you can go make multiple copies. And then there's more details about how much are you doing, and is it really part of an anthology, or where the professor is putting together a lot of work. Then it starts to look like more like what you're trying to do is reproduce the underlying work rather than talking about one little section of some news story.
Excuse me, Al, we have a question.
Sure.
2 slides ago, 2 slides ago, so you said for example, you said that you can, the only reason or an exclusion to being able to use a copyrighted work is that if your copying affects the commercial value or commercial sales, let's say, of the copyrighted work, then you can't use it.
Well, all I'm saying is chances are, if you're doing that, it's tipping away from fair use in almost all situations.
But couldn't you argue that's almost always the case? If I'm assigning an article that's behind a wall that you have to pay for on some database or newspaper, the mere fact that I'm assigning it to 30 students affects the commercial value. You could have bought 30 of these things.
True, but I assume you're doing it for, it's in a
classroom.
A classroom environment, so there's no gain for anyone in terms of the students receiving it. You're doing it for purposes of criticism, argument, comparing it perhaps to some other articles. So you're doing it in a true, I assume, in an academic type environment. Those are all factors that point toward fair use. Yes, you could argue at at the ultimate point, any copying affects the commercial value of the underlying work. But again, it's usually not copying the entire work. It's usually copying a part of a work. It might be a few paragraphs in a chapter. It might be a chapter out of a 50-chapter book. It's one of those things. I'll tell you that the test that a judge came out with years ago was, if you're deciding whether you think it's fair use or not, ask the question in reverse. If you were the author of the work, would you want that to be done in the way that you're doing it in your classroom without compensating that author? Would you feel like you're being financially disadvantaged by the action of that particular professor? And if you felt that, well, if I wrote that, I wouldn't want those chapters to be taken out of my book, copied, and given to all my students, chances are you're starting to go on the borderline of not fair use versus fair use. It's not a black and white situation, and that the Copyright Office circular actually goes through it in much more detail. I must profess that I'm not an expert in copyright law. It's not something I do on a regular basis. But fair use, obviously, from a student and faculty point of view, is a fairly significant thing. And again, I would suggest these are kind of the overviews, but the copyright circular is definitely a good place to get more information. Yes?
One point that you probably want to clarify, and that is that the 4 factors of fair use are taken together.
Yes, they are viewed together.
They're not taken one at a time.
That is correct.
So the commercial factor is just one.
Yeah.
But it has to play into the other factors.
Yeah, it isn't like, if it has any commercial effect on the author, it's taboo. But clearly, if you're doing something like creating a workbook, which is specifically prohibited from being a fair use. Why? Because the author's probably the one that would want to prepare a workbook associated with their underlying textbook, things of that nature. But I agree, the factors are to be viewed cumulatively, and it's a balancing of the interests. And as I say, there's not a black and white answer on all of these, although I think the circular does a pretty good job of steering you in the right direction if you're a professor wanting to use some copyrighted work in a daily presentation or in something that you're handing out to your students. Again, these are more or less the prohibitions on teachers and classroom copying. Again, I would just take, this, by the way, this whole presentation is available for download, so rather than going into all of it in detail. But things like copying should not be used to create or replace or substitute anthologies, compilations, or collective works. It kind of makes sense. I mean, if you're putting everything together that the author did, why can it's not really, how can that be a fair use? You're just copying the whole work. There should be no copying of or from works that are intended to be consumable. So workbooks, exercise, standard tests, are not considered to be fair uses of the underlying copyrighted work. So it's not a substitute for purchasing books. Again, you need to use a kind of common sense. How would you feel if you were the author and these things that are being copied, do you think they're fair or do you not think they're fair? And again, you cannot, by the way, you cannot charge for whatever it is that is being distributed other than the cost incurred for making the photocopies or the like. Limits on copyright. Well, there aren't too many, to be quite honest. The big thing about copyright, and we're going to get to it in a minute on patents, copyright protects expression. It protects what you write. It protects the actual sentences, the chapters, how the chapters fit together. On a music score, it protects the actual notes. On the lyrics, it protects the actual lyrics. On a sculptural work, it protects the three-dimensional work of art. On a two-dimensional work of art, it protects that painting on the wall. It is all directed to expression. it's not directed to the underlying idea if there is an underlying idea in that expression. So what's a good example? I write a textbook and I describe, it could be a physics textbook, and I describe various laws that have been discovered over the years, like Maxwell's equations, Einstein's laws on the equivalence between energy and matter. Those are not, I could write all I want. Even if I was Einstein and I wrote it out, I can't keep people from writing E equals mc squared. Why? Because that is a discovery. That is an idea. That is not the expression of the idea. It's the book that I wrote describing E equals mc squared that's protected, but not the underlying idea. So if you write something and you have a lot of data in it, whatever, it could be anything. It could be a study on how birds migrate. It doesn't matter what it is. If you have a lot of data in it, the data in and of itself is not protectable. How you express that data is protectable. And similarly, if I make some discovery, whether it's in scientific discovery or whatever discovery, maybe you discover something about, you know, some Native Americans that no one knew about. That discovery in and of itself is not going to be protected. Again, if you wrote it up, the expression is protected. And this comes to play with respect to patents, which we'll get into in a minute. But here's the underlying difference. Copyright protects what you write, how you express it, the art that you create, even if it embodies ideas. Patents protect the ideas. The underlying idea is protected in a patent. So if I come up with a discovery and I apply it into the useful arts, I might discover the concept of coherent transmission of light, AKA a laser. If I come up with the discovery of that in and of itself is not protectable, but if I create a working laser, guaranteed it's protectable. That is something in the useful arts based on an idea. So the idea is protected by describing it and showing it in something that is physical. And that's what the patent law is all about. So they're really kind of different animals. And they usually don't overlap with each other. One little thing that sometimes you may say, this is a kind of a small point. Sometimes could be a chair, a table, whatever, something that's actually useful. And it might have something on it that is sculptural. And then the question is, well, is the chair protected? No, the chair's not protected, but the sculptural part of it is. So someone can't, if you had some artistic, let's say fluting, and it really was creative, that in and of itself could be protected, but you can't stop somebody from making a chair. Okay, we can get into copyright infringement. It's basically whoever owns the work has the right to copy it. To prove infringement is simple. You got to show that what the other person did is substantially similar to what you created. So if I write a lyric and someone else is singing a song with a similar lyric, and if they had access to my work, then I've established infringement. So infringement is basically meaning I created something, you have something that looks awfully close to what I created, and by the way, you had access to my work. So as long as you had access to it, it's going to be considered a copy. Most likely going to be considered an infringement. That's to be distinguished from a situation, let's say I write a beautiful musical score, I never publish it, never show it to anyone. 5 years later, someone writes another musical score very similar to mine. And I go and get my registration on my work, and I go try to sue for infringement. Guess what? I lose, because that other person independently created it. So independently created works are not infringements. Doesn't happen too often, but sometimes it does. You hear it a lot in music where someone says, oh, they took those 5 bars out of my song. Well, did they? Did they have access to your song? How similar are those 5 bars? That type of thing. So I don't know how much you want to get into it. Infringement can be direct, indirect, but normally it's a direct infringement. There's other ways. Sometimes you may have someone who's doing something because I asked them to do it. It's more of an indirect infringement. It's really not that important. Copyright remedies. An injunction. Well, that's pretty simple. If I own the copyright, you're infringing it. If I write a book and you're making copies of it and selling it, I can get a court to basically tell you, time out, you can't do it. A copyrighted work, one of the things the author, the owner of a copyright has is the right to make alterations of the work. The right to even, this happens sometimes in two-dimensional works of art, like paintings. The author has the right to kind of mesh it, change it in a significant way, maybe to make it look ugly when it looked pretty. The author has that right. There are some things, usually it's only the author that has the right to do it. Sometimes on a issue of criticism, there's a question of fair use as to if someone wants to show that work of art and perhaps modify it in some way to say, well, this really is similar to some other work that was created 200 years ago. If it falls under fair use, they probably can do it. But if it's being done for commercial purposes, only the author has the right to do that. Some of this, by the way, is governed. We have our laws, but the United States is also party of what is known as the Berne Convention. And it's a treaty that virtually all countries in the world abide to. And this has to do with only the right of the author to even attribute the work to that author. Someone else cannot say, I'm the author of that work. Even misattributing the authorship is a violation of copyright law in most situations. So there have been situations like that in the past, but when the United States became a member of the Berne Convention in 1978, it basically put us on the same position as most of the rest of the world. For instance, before 1978, if you didn't put a copyright notice, the C in a circle, on your work, you could lose your copyright. Under the current law, there is no requirement to put C in a circle on your copies. It helps, but it's not required. And you don't lose your copyright if you fail to put the notice on your work. So. Anyway, one of the remedies is injunctions. The other one is impounding. Impounding is simple. If these infringing copies of your book are coming in from China, guess what? You can stop them at the border patrol where the containers come in. You're also can obtain damages and profits. Well, the difference is damage is something you can show because of something I got hurt to some monetary value. The profit is kind of similar to that concept of damage, but it simply says if the author would have made X dollars in profit, the author is also entitled to that X dollars in profit, even if it's more than the damage that he or she suffered when the copying was done. Actual damages and actual profits. This is getting into the minutia. There's one other measure of damages, and it's called statutory damages. Sometimes you create a work, you may not be publishing it, but someone's still got access to it. You registered your work, and someone's starting to copy the work. So you haven't had any damage in the sense that you've been selling these products, and now this other person is hurting your sales because you never had any sales. You weren't selling it. Nevertheless, you are entitled to what are called statutory damages in lieu of actual damages. And as you can see, the statutory damages can range from a minimum of $750 to $30,000 as a normal range. But if it's a willful infringement, meaning the other entity not only did it, but they really did it with malice. I mean, they really meant to rip you off. And if you can prove that, you can get statutory damages up to $150,000. However, again, the court can look at the total circumstances and can reduce those amounts down to as little as $200. That normally doesn't happen, but nevertheless, in a situation where it probably was an innocent infringement or they thought they had the right to do it, et cetera, chances are the judge is going to reduce the award. But anyway, it's a different way of collecting that is only available in the copyright side, not available on patents, not available on trademarks. And it can be significant in shutting down an individual or company who is copying your work. So it can be quite significant. Okay, duration. Since 1978, and that's all that what I was talking about on the Berne Convention, it's the life of the author plus 70 years. So I create a work, you know, if I live 10 more years, I still get, whoever owns my copyright has the right for another 70 years after that. And if it's a work made for hire, like you, again, that situation where you were writing computer code for your employer, the employer has, it's either 95 years from the date it was published or 120 years from the date of creation. Why the difference? Well, you might create a work and never publish it. So in either case, the copyright will expire, but you can see the term of a copyright is quite long, much longer than patents, much, much longer. Again, it's because it's for a different purpose. This is protecting expression. So if I write a book, shouldn't I be entitled to that book? Shouldn't my ears be entitled to that, to keep others from copying that book? It's quite different than coming up with a new design on a cell phone, which the courts say, or the law says, okay, you can have exclusive rights to it, but it's going to be for a much shorter period of time. They're for different purposes. This is for expression. Patents are for protecting ideas which are fundamental to, really, to the nation's economy. Okay, that's, any questions on copyright? We kind of covered it pretty fast. Sure.
A lot of this audience here is geared towards information systems, information technology. Mm-hmm. We have, of course, debates looking at copyrights versus patents and different types of patents. In the area related to your work with Apple, Nokia, Samsung, the back and forth, what are you seeing in terms of some of the emerging trends in terms of where software patents and infringements are going, the issues of embedding multiple layers of technology and intellectual property?
Okay, well, it is definitely evolving, and it's evolving rapidly, primarily because of several Supreme Court decisions that have come out over the last 3 years. Most notably, with respect to computer-implemented inventions, it's a case called Alice. Alice was one of the parties. And in the Alice decision, the Supreme Court basically said, just having a computer, an invention that can be run on a computer, if it's just a computer program, and we'll get into what that means, in and of itself, it's not patentable subject matter. Subject matter. And we haven't gotten to the patent slides yet, but their subject matter is very broad in patents. But patents do not encompass underlying laws of nature, abstract ideas. So what the Supreme Court has said is that a computer algorithm, in and of itself, is considered an abstract idea. Which means if you write if someone comes to me with an algorithm and says, I want you to patent it, in and of itself, I have to say you're never going to get that patented, because the patent office, when they review your case, are going to say your patent claims are directed to a computer algorithm and therefore are outside of patentable subject matter. So then, of course, the rub is, well, how do I protect it? Well, the Supreme Court said, in order to protect something that is primarily algorithmic in nature, you have to do something substantially more than the algorithm. Substantially more. Those are the words. Nobody knows exactly what the words mean. It's like pornography. You know it when you see it. That's the same idea. You know it when you see it. And you know, the courts are going to debate this for some time. I'll give you my quick read on it. If you came to me with primarily an algorithmic invention, I'm going to say to you, I'll give you an example. It might be a way of hedging one risk versus another, because one of these actually went up to the Supreme Court. So it's, you're hedging one risk vis-a-vis another risk by manipulating maybe a third risk. It doesn't matter what it is. The Supreme Court came down and said, there's nothing there. That's an algorithm. You could do that on a piece of paper. Maybe you can't run it fast, but you can do it on a piece of paper. If your underlying algorithm can be done on a piece of paper or it can be done in your head, chances are you don't meet the substantially more test by the Supreme Court. So what do? Well, you can do by, in essence, doing something more with it. Let's say because of that hedge, if some criteria is met, you may say, if that criteria is met, I am going to send a signal to some remote server, which is going to instruct that server to start some other program, which in turn will cause something else to physically happen. I don't know what it might be, but something physically to happen. If you do something along those lines, I would say we could make a very good argument that what you have is substantially more than an algorithm. And that's the kind of thing, we are facing this all the time now. I bet I've had 20 cases already since the Alice decision, and we're fighting this Alice test. I'll give you an example. When you go on your TV guides and you're going through the guide, it might be Netflix or something else, and it kind of figures out because of things that you've looked at in the past that it might suggest doing something. You might want to see this movie because you saw these movies, or you might want to see this documentary because you were watching some other documentaries. We have a client overseas that does that. They write these, they call them recommender engines. And we're having all kinds of problems on the issue of, is that strictly an algorithm? And these cases were written because they came from overseas. They were written before the Alice decision was rendered. So when they wrote the case, no one was aware of this. So it's in essence like kind of having your legs cut out from under you because you had no way of anticipating the situation in the first place. It makes for very tough what we call prosecution. So anyway, any other questions before we move on? Okay.
Al, why don't you start in with your discussion of Apple, Nokia?
Okay. Big thing to remember, if any of you folks are out there going to invent something in the future, which I'm sure some of you will, a patent doesn't give you the right to do anything except exclude. It doesn't give you the right to make what you just invented. And you may say that's absolutely, doesn't make any sense, but it does make sense, and I'll explain it. It gives you the right to stop others from making, using, selling, importing, whatever it is you invented, okay? And you may say, well, why doesn't it give me the right to make what I just invented? Well, because what you made may be an improvement on something that someone else made 2 years ago. So if I invented going back to the laser, if I invented the concept of a laser, no one else had a laser. So I write a patent, I explain how I make a laser. And I get a patent directed to light amplified stimulated emission of radiation. That's what a laser is. If I get a patent on it, guess what? Anyone else who makes a laser infringes my patent because my claim is that broad. However, someone 2 years later says, okay, you were using, I don't know, helium to make your laser. I got a way to make it with effectively on an integrated circuit chip, which is what many lasers are made on. Clearly an improvement over using helium. I can get a patent on my improvement, but guess what? I can't make it because I would infringe the other person's patent on the fundamental laser. So what happens? Well, it's simple. The person who owns the patent on the laser has to license me to make the improvement, and I have to license them if they want to make the improvement themselves. If the person who owns the fundamental patent doesn't want to grant me a license, guess what? I'm out of luck. It happens. Not often, but it happens. That's the fundamental idea of patents. It gives you a right to exclude others from something you invent. What does invent mean? It means it's new, means no one's done it before, and it means it's unobvious, meaning what other people have done and what you have done, you have made an unobvious improvement to whatever was done ahead of you. That is a fairly simple test, but that is the test as to whether your invention is patentable. What I've been talking about are utility patents, which is basically what everyone thinks about as a patent. I actually have some here if you want to take a look at them after the talk. They last for approximately 20 years from the date you file. There's a little massaging of that, but that's basically it. It can be based on an earlier filing, which is called a provisional, which is a kind of a fast way to get your case on file. And you must file, if you do file a provisional, you have to file your utility within 1 year. Okay. There's also a thing called design patents. Guess what? The biggest award that Apple got against Samsung, it wasn't on a utility patent. It was on a design patent. What's a design patent? A design patent is protecting the ornamental features of a utilitarian object. So in the case of Apple, it had to do with the design of a smartphone. And it had to do with how the icons are laid out. It had to do with where the center, whether the button is round or square. It has, they filed on every conceivable variation of their phone. Their initial filing had 50 embodiments. They covered it every way but Sunday. And guess what? Samsung was found to infringe the design patent, and they are standing, I think it's a $680 million award against Samsung, which is almost certainly going to the Supreme Court. Okay, those are the two main kind of patents. Patentable subject matter, we just were talking about it. Patents cover processes, machines, manufacturers, which are things that don't move, compositions of matter, chemicals, and any new and useful improvement. So that's that situation I was talking about with the laser. A laser is a machine, arguably, and if I made an improvement, it's an improvement. So that's everything that's under the sun, except things like abstract ideas, computer algorithms. Or, guess what? Finding a part of your DNA that represents a particular gene. And that's another Supreme Court case. So the BRCA gene that's associated with breast cancer, the discovery of that was found by the Supreme Court. Guess what? It's a discovery of where the gene is in the DNA. That's not protectable by patent. Although they did have a patent. They lost their patent. However, using that gene to what they call, I think it's called a cDNA, and I forget what the C stands for, but it's basically modifying the gene for other testing purposes. That was a humanly changed DNA structure, and therefore that was protectable. But finding where the gene was, which is what they did, finding where the BRCA gene was, in and of itself was not protectable under the patent law. That was a big case. Computer programs per se are not patentable. They're eligible, but they have to be used for something. Okay? These are exactly what we were just talking about. Laws of nature, natural phenomena, abstract ideas are not protectable in and of themselves. So, but a claim, as I said, directed to one of those three categories, law of nature, natural phenomena. If you do significantly more, meaning you do something with that idea, do something with that gene, do something with that algorithm, then maybe it's protectable by patent. Yeah? For a utility patent? Design patents are relatively inexpensive, other than the cost of the drawings. But a utility patent, depending on the nature of what it is, because it is not a fill in the blank, it really is, it's written from scratch. And it's a fairly involved process. I have some examples here, you can take a look at them. A typical utility patent to prepare and file, you're in the range of typically $5,000 to $10,000. And then to prosecute the patent, meaning to get it through the patent office, because the patent office examines patents. They don't just register patents. The examination process can go from very easy to very hard. Typical examination process, which is the examiner will say, well, I don't like this and this, or I think your claim is too broad. In the back and forth, the examiner will look at what we call prior art, meaning what other people have done before you, and they say, well, that prior art basically teaches your invention, or that prior art suggests your invention. That whole process of going back and forth with the examiner, amending your claims, is typically in the order of about $5,000. So from the filing to the grant, I would say anywhere from $10,000 to $15,000 for a typical patent. Okay, this is as we were talking about this idea that abstract laws of nature, abstract ideas. This is actually from the Patent Office website, and this is how they examine it to determine whether you have significantly more than the abstract idea. So the flow chart is easy to show, but it's not so easy to apply. That's all I'm saying. Okay, why get a patent? Well, there's many reasons for getting them. There's two primary reasons. You use them offensively, meaning I get a patent on some fundamental idea that is patentably subject, it has patentable subject matter, and I basically tell the world, here it is, you want to use it, pay me. That's how if you want to monetize something, that's one way to do it. Now, if they use it without paying you, guess what? You sue them. So that's what it's using it offensively to exclude others, if you wish to exclude, or you're using it offensively to derive revenue through licensing. And you can do this, you can allow a company to use your invention only for certain purposes. I mean, there's many, you can basically slice and dice your rights however you wish. And you can use them defensively. Many times a company has a product and they know they may infringe somebody else's patent, but if they have their own patent portfolio, guess what? They can use their patent portfolio to counterclaim, to sue the other party if they get sued by that party. So sometimes you want to build up your patent portfolio to protect yourself against others suing you. So those are the two main reasons for patents. And we can go through the infringement. Let's go, there's different kinds, but basically it's whether the person is doing the same thing that you have described in your patent. And the remedies are very similar to the copyright remedies. You can get an injunction, meaning you can stop the other party, you can stop them from importing it, you can collect damages, you can collect profits if you can show that you're entitled. That's a little trickier. And if you can show the other person was copying your invention, infringing it willfully, the court can increase those damages up to 3 times. And that can be significant. That can be real significant. And you can also get attorney's fees in that same situation. So that basically covers the remedies. What roles have patents played in the smartphone? A lot. A lot is the only way I can put it. There are literally thousands, and I am not exaggerating, thousands of patents directed at everybody's phone every phone that you have here. I guarantee there's at least 1,000 patents that cover that, some feature in that phone. And this gives you a very brief, I mean, phones started back in the early 70s up to 90, it was all analog. You folks aren't even old enough to remember that. Then they started the 2G, and then it went into digital technology. First it was 2G, 3G, I don't know if you ever heard of these, 4G, which is now LTE, and now we're pushing 5G, by the way. And it's actually starting to be implemented. 5G is just a faster version of 4G LTE. But significantly faster in most cases. Okay, so that's the technology. So that's probably, who are the major players? Well, this is, believe me, not a complete list. Apple, Samsung are clearly the 2 dominant players in the smartphone world. Nokia was on the handset side until they sold the business to Microsoft. They are still very big on the infrastructure side, which means the cell towers, all the networking equipment, all the stuff that goes on behind the scenes that makes that phone work. Google is also big in it now because so much of their technology is tied, they're in the phone business and they're using phones and all aspects of cellular technology in their search engines and the like. HTC is a Taiwanese company, Huawei is a Japanese, is Chinese, as is ZTE. LG is Korean, and Microsoft, since they bought the phone business from Nokia. This gives you some idea of how many patents we're talking about. Issue patents and published application. When you file a patent application, after 18 months it gets published. So as of February, last month, in the case of Apple, they had over 12,000 issued patents, and they had over 8,000 published applications. Now, I grant you, they're not all directed to smartphones, but I guarantee you the vast majority of them are. And just look at those numbers. The numbers are staggering. I mean, with the exception of Samsung, because they're into many other things besides cell phones. With the exception of Samsung, whose number is, on the cell phone side, is much less than that number. Most of these other companies have a substantial part of their portfolio into the phone, in the phone or the network side of the phone. So, this gives you just a brief history, and believe me, this is not in any way a total, as to the various lawsuits that have gone on regarding smartphones. It goes all the way back to 2009 when Nokia sued Samsung on various patents that Nokia had. You can spin through this yourself. I'll give you one little interesting war story on this, and it has to do with two patents. This patent, which maybe you can see, this has to do with how you can put an antenna into part of the phone, which can also be used for the audio. And then there's another patent. This other patent, it has to do with the, I forget now. It had to do with the camera, and how the camera digitizes the image and how it talks to the processor, both for digitizing the image and sending it to the processor, manipulating it, etc. Those two patents, our office, I didn't personally, but people in my office prosecuted these two patents to issue. Those two patents, if you look back a few slides, were involved in a lawsuit that Nokia filed with the International Trade Commission back in 2011 against Apple. What's the International Trade Commission? It's a separate court that hears cases where one party says, I have a US patent, and another party is importing product into the United States that I consider to be an infringement of that patent. And the International Trade Commission can say, you know what, time out, guys. If you're infringing that patent, the International Trade Commission can block the importation, okay? Guess what? Apple doesn't make their phones in the United States. They all come from overseas, mostly China. So what happened initially, the International Trade Commission looked at, there were 5 patents involved, and they initially made a determination that they were not infringed. Nokia went back to the International Trade Commission and said, well, we think you should look at these two in particular. And they made the presentation. And the International Trade Commission, about a month later, said, you know what? We're going to relook. We think there might be an issue of infringement. So this all took place literally in 2011. Now look what happens. This was their decision. Unfortunately, the date was, it's May 26th. That was May 26th when the International Trade Commission said those two patents may be infringed. They didn't say they were. They said they may be infringed by Apple's smartphone, whatever one they were making at the time. What's the difference in the dates? May 26th, June 14th. We're talking like 3 weeks. All the litigation was settled between the two companies. No one ever said why. In my opinion, that was why. They were going to, if they won, they could have stopped Apple from selling phones in the United States. That was a showstopper, an absolute showstopper. It never got publicized. Neither party ever said a word about it. But if you look at the facts, and I was there, I mean, it was our stuff, so I know it was involved. If you look at it, to me, that's the only logical conclusion. I have heard, again, neither party ever talked. They don't even talk to their attorneys, by the way, because we were simply the ones that prosecuted. We did not litigate the patent. The patents were litigated by another law firm. But I have heard that they are probably getting $4, Nokia, licensing fees for every Apple phone sold in the US. So you're talking real money. Since then, there's still been many, many cases. This gives you some idea as of last month, how many smartphone manufacturers have been named in litigation. There's still many lawsuits going on. However, Nokia last month settled with Samsung through what they call international arbitration. They both agreed to have it heard through an independent panel to determine what monies Samsung owes Nokia for every phone they sell. And they, whatever they came to, 1.02 billion, well, $1.1 billion. Believe it or not, the stock market viewed that negatively, and Nokia stock took about a 15% hit on the grounds that they should have got more money out of the deal, okay? And there's a similar one going on right now between Nokia and LG. And there may be others, but those are the two that I know about. So when it comes to your cell phone, your smartphone, the patent wars have been absolutely extensive. They're all over the place. And by the way, it's not just in the United States. The litigation's gone on in Europe. They've gone on in other parts, in Asia and other parts of the world. So anyway, it's an interesting area, but the intellectual property does matter, I guess is what it really comes down to. Anyway, any questions on any of this, I'll be happy to try to answer.
Questions from you all in the audience?
Just out of curiosity, are any of you folks thinking of going to law school? Okay. For general practice, or are you on the intellectual property side, perhaps? Okay. Did I see another question? Anyone else? Okay.
Okay, I'm going to ask two quick questions. One, what is your most interesting wraparound patent case that you've been involved with that you can talk about? And
in terms of a case that we prosecuted and litigated?
Yes.
I've had a few.
Okay.
Nothing as dramatic
as that, in terms of dollar amounts.
These just to give you an idea, when cases like this go to court, you're not talking one or two attorneys, you're talking a team. You're literally talking cases that can easily run $1 million a month in terms of attorney's fees. They are extremely extensive, typically with anywhere from 5 to maybe 15, 20 people working on that case, literally all the time. It's a huge, huge endeavor. I've been involved in a couple unusual ones. I don't know if you're talking about something, a rapper, I don't know.
Yeah, real quick, yeah.
We had a case years ago, and I was just starting out. My senior partner had obtained a patent for two gentlemen, nice fellows. One of them was an iron worker. He'd go up on the buildings, and they were both. And the other fellow was he was an engineer. And you may think this is crazy, but this is the invention was directed to an ornamental Christmas tree hanger. The hanger that you use to put an ornament on a tree. Okay. So I was not involved with the patent, but the patent was allegedly being infringed by a company up in Boston. So we were kind of doing the case. It wasn't technically a contingency, but these people didn't have much money. So it was a contingency. In reality, it was a contingency because they couldn't pay us, with minor exception. So the case went to trial, and I was the assistant on the case, so I wasn't the lead prosecutor. But I'll never forget this. The other side, are you familiar with the process of litigation? In a civil litigation, you file a complaint, and the other side files an answer. So I say, you infringed my patent, you did this, this, and this, okay? And therefore I'm entitled to damages, whatever. The other side will come back and say, well, no, we never made the product, or if we did make the product, it doesn't have this feature of your claimed invention, or even if we did it, it really is not a patentable invention because your invention is anticipated or suggested by someone else's. All right, so it's the typical, what we call pleadings. And after the pleadings, you get into discovery. And in the United States, discovery is on a civil trial is pretty extensive, meaning I can ask you, as a defendant, anything that's relevant to the case, I can ask for documents, I can take your deposition, I can take a deposition of various people in your organization, I can ask for answers to what we call interrogatories or questions, I can ask requests for admissions. The other side can do the same thing. It's a big process, a lot of stuff going back and forth, back and forth. And needless to say, everyone is kind of trying to be a little cutesy, meaning you don't want to answer if you don't have to answer. If you think it's privileged, you don't do that. If you think if there's a way to answer it without really giving them what they want, you're trying to do that. Everyone's trying to maximize their client's position. All right, that went on in this case. So in this particular case, the attorney, when we asked for certain documents to be produced regarding their sale of this product that we said was infringement, they said they couldn't find them. Okay. The case goes to trial. This is the God's honest truth. And it was to a judge that was, it was federal court. It was sitting, the judge up in Boston was a designated judge. He was a traveling judge. He actually did not sit in the District of Massachusetts. He was from Washington State. But he was there. He was the judge on the case. And we're going through and trying to establish that certain documents that had been requested, which would establish that they had infringed, they had failed to produce. And so the judge did a timeout. You don't see this too often. And the judge, they had the person on the stand that was answering the questions about why these documents weren't produced. And the judge can ask questions. By the way, if you're ever in civil litigation, or in criminal, hopefully no one's in criminal, but if you're ever in litigation, the judge can ask questions besides the two attorneys, whoever the attorneys are. So the judge said, Mr. So-and-so, who was responsible for looking for these documents? And he named the person. And he said, why weren't those documents produced? And this is the God's honest truth. He said the man that was told to find them was legally blind. When I heard those words, I said, we won the case. The case was over at that point. The attorney never in a million years thought that witness was going to say that. So all I can say is a word for the wise. If you ever get into law, you talk to every witness that you're going to put on the stand, you ask them every question imaginable, because you never, trust me, you never quite know what they're going to say. And here was a case where the attorney for the other side really thought that he never thought in a million years that they put a blind person to find the documents. And when that person said that, the judge, I tell you, the judge almost fell off the bench. I'm not kidding. And the case was over. I mean, we won the case. So that's kind of that's a very unusual situation. So anyway.
Other questions from you all in the audience?
Okay.
Otherwise, I want to thank you, Al, very much for coming.
One more thing. If anyone has, besides downloading the materials, if you have any questions, well, you got the website. My email's on the website. You can always shoot me an email or give me a call. I'm more than happy. If someone's looking to go to law school, you got some questions, give me a call. It's the least I can do. So, go out there and beat the bushes, invent things. You folks are young. You got the world ahead of you. Go ahead and grab it. That's my suggestion. So.
Well, thank you very much.